Is 50-50 typical in Florida, or is the court have a typical preference?
Well, it actually varies around Florida. There's no requirement. The legislature has tried to pass certain laws that would create a 50-50 presumption, but it has not happened so far. So there is no 50-50 presumption in Florida under the law. However, the judges vary around the state, and I think they seem to be moving toward a 50-50 in most cases, if the parents live within a reasonable distance of each other. So we
So
are seeing that.
right. So if 50-50 is not the presumption, then what are the determination factors for custody determination?
So this is something that requires the court to look at a number of factors. We call them the best interests of the child factors. And that is pretty standard around the country as well. In Florida, there's 20 plus best interests of the child factors that the court can look at and is required to consider. Some of them won't apply in every case. You know, if there's a substance abuse problem, for example, is one of the factors. And in some cases, that's not an issue. The court just skips that and goes over to the next factor. But they do have to look at all these factors that are apparently based in social science research. I'm not sure how valid the research is. It's old, but you know, there are things like which is the parent that cares for the kid on a regular basis. Um, do both parents know the kid's friends, teachers, physical limitations, medication needs, who takes the kid to the doctor's appointments? You know, it becomes a very specific analysis by the judge on, you know, who's really the one the child depends on. And is the other parent capable of doing those things as well? They just haven't during the marriage because they were, you know, together and one parent worked more hours than the other. And so the judge will give them a chance to be the 50% parent if they want to.
So you mentioned there's 20 something factors, right?
Yes,
Would you mind like perhaps sending me a link or a list or
sure,
something that I could share with
absolutely.
the audience? What about evidence like, let's say, text messages, screenshot, or maybe uh, phone messages, or maybe like video recording? I mean, is Florida a one party or the two party?
So, yeah, well, and that's a good point. And frequently, text messages come in almost all of our cases nowadays, honestly. That's a very common, and emails and voicemails. And those are, you know, things that people transmit. And if you can authenticate them, then by and large, they will come in. What I find is that people always have a different interpretation. You know, each party thinks the text is going to help them, and it doesn't really help anyone because it doesn't really, the judge can't even make sense of it half the time. So I think
Mm,
a lot of people are a little too dependent on written documents in custody
mm.
cases, that they can be helpful, but in small quantities. You're not going to get in 100 pages of texts and have that be really useful. As
Okay.
far as the wiretap law, so we have no restrictions on video per se. It's the audio portion that where the wiretap statute comes in. But yeah, you do need to have consent in order to have that be admissible.
So it's
Uh,
a two-party consent state.
yes, it
Yeah.
is. But I have seen a lot of domestic violence cases. They will look at the video, whether or not they listen to the audio. They will certainly look at the videotape.
I
And
see.
in
So the video doesn't require consent. That's
correct.
interesting. But the audio require both party consents in order for you to use that.
Yeah, it's a popular misconception, I think, but the wiretap statute is for audio. It's not
Yeah,
for video.
I mean, that's really good to know. I think, yeah, I think a lot of parents don't know that. I didn't know that at all.
Well,
So,
and a
so
lot of people have like a Ring doorbell or things that cameras for surveillance around the house, and those things can be extremely valuable. I had a mother captured on tape having her 5-year-old blow in the breathalyzer to start the car, and that was admissible in court.
Oh my God, I'm 5 years old. Oh
Yeah,
God.
she had an intoxilock on her ignition, and she
Wow.
had the kid blowing it in the, I mean, this was the morning before school, and then drove the child to school
Yeah. Oh
after he
my
got off
God.
the car.
Oh my
They
God.
would not have known that if they didn't have surveillance tape on the outside of their house, which, was just a video, and it was extremely powerful.
Wow.
So that's a very important tool, and it's actually inexpensive tech now for most parents. So that is something they should all be aware of.
That's great. What about witnesses? Let's say, maybe the sibling, like adult siblings in the house that or maybe, cousin, auntie, uncle, grandparents, like, friends, can they testify? And I mean, how valuable is that to have witnesses?
It can be very valuable if they've actually witnessed incidents that are at issue. Um, I think that there's sort of a misconception in the public that, well, we need character witnesses to come in and say, I'm a good mom. And that's just not a thing, actually. They're
Right.
not helpful.
Yeah.
If they're just going to say, yeah, I've known Susie as a parent at school, and she seems like a nice lady, and we did the bake sale together, But if, yeah, Susie and I and the kids all went to the beach and we saw dad whack the kid, when he didn't come fast enough, that's a little different. So they can be extremely helpful. They don't always want to get involved, but if it's a case of a kid's safety, I have found that neighbors and friends and family members will come forward.
What about cases that, especially early on, when one of the parents, like maybe they weren't prepared, they didn't have a lawyer that represents them, and they were coerced into signing or agreeing to something that is really adversarial to them. Like let's say that suddenly they were giving up so much physical custody or agreeing to a lot of different things. So what are their options? Can they go back to court to ask for change? They might already sign a settlement out of court. Like, can they appeal to that? Oh,
Well, that's a great question too, and that happens frequently. People will start out without lawyers thinking, we're going to get divorced, we'll just do it ourselves. And next thing you know, you've signed some terrible thing. It depends on the timing. So if you've signed a document, but it hasn't actually been put through the court, it's not yet a court order, then you can try to essentially, dispute it. If somebody tries to turn it into a court order, then you can go to the hearing and say, you know what, I didn't realize what I was signing. I didn't have a lawyer. Now I do. I'm not agreeing to that anymore. And the court will not actually turn it into a court order. If it has now been turned into a court order, then you can seek to set aside the document, claiming that you were misled, or whatever you want to say about it, that it was not a voluntary act, you were coerced. You can try to do that and move to set it aside. um, if you discover within the appeal period that you signed it and the court denies your motion to set aside, then you can actually appeal that and try to overturn it that way. It's a 30-day window, though. It's a very short time frame. Um, you can always go back in and seek to modify. So if you've sort of missed all the short deadlines and you realize, it's now a year later and you realize, wow, this is terrible. I should never have signed this thing.
right.
And now you get a lawyer who says, yeah, this is terrible. You should never have signed this thing. And by the way, this isn't in the best interest of the child at all. The kid is suffering because you signed this terrible document.
Yeah,
Then you can go back and you can ask for a modification, but you have to demonstrate a substantial change in circumstance. It can't be that I didn't realize I signed something dumb. You have to say, I realize that this is bad for the child. And what's happened in the last year, we've learned that this is really harming the child.
I see. How long do you have to file the motion for set aside?
So the motion to set aside is, there's a bunch of grounds that you have a 1 year time frame to file. And then there's a few things that are longer than that. But really, basically, the main crux of it is a year.